Hello and welcome to Liberty Law Talk. I'm your host, Richard Reinsch. Liberty Law Talk is featured at the online journal Law and Liberty, which is available at lawliberty.org. Today our guest is Greg Weiner, author of the new book, The Political Constitution, The Case Against Judicial Supremacy. Our listeners will know Greg as the contributing editor to Law and Liberty, one of our contributing editors, and a frequent guest to Liberty Law Talk. He's provost and vice president now of academic affairs, an associate professor of political science at Assumption College. He was a senior aide, I had forgot that, Greg, to U.S. Senator Robert Kerry during the 90s. He's the author of Madison's Metronome and American Burke, The Uncommon Liberalism of Daniel Patrick Moynihan. And recently, which he recently appeared on our show, Old Whigs, Burke, Lincoln, and the Politics of Prudence. Greg also was recently named as a visiting scholar at the American Enterprise Institute. Greg, glad to have you on the program today.
Good to be back.
So, Greg, the title of the book, The Political Constitution, The Case Against Judicial Supremacy. So, what is a political constitution? Is there another kind?
There is another kind that's being asserted, which is what I would call a judicial constitution, which is asserted to be the property of technical experts in the law, as opposed to and to unelected experts in the law, as opposed to constitutional interpretation being the province of the people acting through their elected representatives. So I would say a political constitution is one in which constitutional controversies are generally resolved by political rather than judicial means.
What's an anti-political constitution?
Well, I think judicial engagement on the libertarian right represents an anti-political constitution, just as I think that judicial activism of progressivism represents an anti-political constitution. An anti-political constitution is one in which fundamental value choices and even more ordinary constitutional choices are imposed on us by a priesthood of judges.
Okay. Now, think about judicial engagement. I've tried to describe it one time in an interview. It provoked several responses on the notable medium of Twitter from Randy Barnett. He said I got it wrong. Among other things. So maybe tell us more about judicial engagement, because you talk at length about it in the book, has a method of constitutional interpretation and power that you disagree with.
I do disagree with it. I would describe it as a disposition for judges to be assertive in protecting what are assumed to be natural rights that are in the Constitution. So, for example, Professor Barnett refers to a presumption of liberty rather than a presumption of constitutionality in judicial review. So that this, as Adam White has put it, this would literally put government on trial. To be forced to, the political community would have to justify its actions before unelected judges. So it's a rigorous philosophy, and it's a defensible one, but it is, I think, not a Republican one.
So thinking here about the presumption of liberty, what does that mean exactly for our listeners?
Well, it means that when when government is making a claim to authority, the presumption is not in favor of the constitutionality of what the elected branches have done, but rather of the liberty of the individual. But it's the liberty of the individual divorced from the political community, not the liberty of the individual in the political community.
So that's an important point, too. Would that amount to, so you're testing federal law is challenged by a citizen. The presumption of liberty standard, is that comparable to what we think of as within tiered scrutiny of strict scrutiny? That is to say, the government would have to show it's used, it's got a compelling interest here, and it's used, responsible means to achieve it.
Yeah, I think that's basically right, especially by way of analogy. Now, it's important to note
they
that
will
there are
dispute
several
that.
flavors.
They tend to dispute that, I found.
Yeah, they do, and there are, in fairness, there are several flavors of judicial engagement.
They being typically Clark Neely has said that's not what he means, but I struggle to know what else it means. But go ahead.
I do too. I mean, I think it's basically I think that they might defensively deny that there's a standard of strict scrutiny, but to your point, it seems to me to be the equivalent. That judges should scrutinize acts of the political branches on the assumption or with a presumption in favor of the individual challenging them.
So, one more on this judicial engagement part. So, a constitution of whereby judges use certain clauses, sections of the Constitution, as a sort of carrier of natural rights, which can then be vindicated by a judge. Most prominently, I think it was the Ninth Amendment, and also the Privileges or Immunities Clause of the 14th Amendment.
Right, which both become open-ended. So when Robert Bork famously or infamously, depending on your point of view, described the Ninth Amendment as an ink blot, it is a provision covered with ink so that you couldn't quite see what was under it. What he means is not that the Ninth Amendment is null, but rather that it is too imprecise for judicial application. So the Privileges and Immunities Clause, I think you can reasonably interpret based on the historical evidence to apply the Bill of Rights, the first 8 amendments to the states. But there is, in the debates over ratification, there's not a mention of applying the Ninth Amendment to the states, or at least that's not the primary theme. There's repeated references to the first 8 amendments.
And that also is to say, what do we make of the 10th Amendment? The 10th Amendment in conjunction with this claim of natural rights, and the 9th, which can then be applied through the 14th Amendment. Where does that leave the 10th, which is the right of people in the states to self-govern?
Yeah, I'm with Kurt Lash on this in thinking that the 9th and the 10th Amendments combined are sort of 1-2 punch protecting the system of federalism, so that the 9th is a principle of construction according to which Congress is limited to its enumerated powers, and the 10th works in tandem with that. I don't think it would make sense to say the 10th applies to the states through the Privileges and Immunities Clause, because it would be sort of redundant.
Yeah, definitely. Now, I want to come back to the beginning of the book, and this is literally the first 2 sentences of the book, because people might be confused and thinking, okay, we're going to have a discussion about judicial supremacy, which means inevitably we're going to have a discussion about the text and interpreting the Constitution. That's not really what you say this book's about. You say, in fact, this is not a book about constitutional meaning. It is a book about constitutional authority. What do you mean there?
What I mean is that as I say somewhere in the book, the fact that a question is constitutional does not mean it's judicial. I think we tend to make that leap without enough thought today, and it becomes reflexive. So what I mean is, it's a question of the question I wanted to explore in the book was the constitutional authority of judges to impose their vision of the Constitution, as opposed to the right of the Republican branches to the elected branches to resolve constitutional disputes politically.
So we're thinking about that as well. And I think this is a part of the judicial engagement movement. What is politics? And what is this? Is there a pre-existing thing called a public, a we, that has its own separate status apart from the individual? And I think the answer there is no. There's the state and the individual and natural rights. You say this is a book about politics and the largely lost and noble sense of that word. Talk about that.
That's right. I think as a general proposition, the libertarian constitutionalists tend to approach this from as though the world began with Locke, when in fact there is a very rich tradition of politics in which the founders were steeped and well educated, by the way, that sees the individual as politically situated, as involved in a relational posture, as you've written. So that sense of politics as a noble undertaking, as a common pursuit of shared ends, and by the way, one in which we can obligate one another, and there is a virtue in suppressing my personal appetite in favor of what people around me want, that has been really largely lost. And I think it needs to be reclaimed. One of the reasons I wrote the book was certainly judicial engagement has been heavily debated and on both right and left. I don't think there was necessarily a ton to add there. But what judicial modesty was lacking was a political justification. In other words, there's a political reason in the Aristotelian sense of politics for judges to refrain from imposing themselves because it short circuits the political process.
Now let's think about this more in depthly. We've had judicial review precedes Marbury versus Madison, is a part of Anglo constitutionalism. It's brought to this country. This is a part of who we are. So you're advocating for, though, situating judicial review not in the way we think of it as sort of a final authority, not just final in time, but final in authority, which I think is largely how we treat it now. You're advocating for judicial review as a part of the constitutional process, but not definitive or supreme.
That's right. So I think there are two ways that we can think about constitutional questions. One is sort of a line, a railroad line. There's a series of stops where first Congress passes or doesn't pass a bill, then the president does or doesn't sign the bill, and then the courts are the last stop on the line. That's what I call a linear view of the Constitution. And James Madison, who's got pretty good originalist credentials, said that giving the judiciary the final word in sequence was never, I think I'm quoting correctly here, was never intended and can never be proper. The other way to look at it is a more cyclical or circular view where all three branches are engaged in an ongoing conversation, but where the judiciary is not exempt from the normal controls of the separation of powers. So one of the reasons I bristle a little bit, although I've certainly used it, at the idea of judicial restraint is that we don't think in terms of presidential restraint or congressional restraint. We think in terms of the other branches checking them when they exceed their bounds. So while I do think judges, just like members of Congress and presidents, should have a robust and thoughtful constitutional view of their office and should not exceed it, we don't depend on that. We depend on the other branches to check them.
Now that raises the question, though. They are, in manner of appearance, final in time. It's hard to undo a court decision. How do you see this process you're describing playing out?
Well, there are a number of ways that court decisions can be challenged, and perhaps more importantly, prevented. The Constitution gives the Congress the power to set the jurisdiction of the Supreme Court in most cases. There's the power of impeachment, which has been completely neutered with respect to judges. And there's also, as Lincoln said in his speech on the Dred Scott decision, that you don't have to accept, the political branches that is, don't have to accept a decision as binding precedent. They can continue challenging it. We saw that in the Smith decision where Congress came back and passed the Religious Freedom Restoration Act, and there was an ongoing dialogue between the branches there.
So you're saying, famously, Abraham Lincoln, in response to the Dred Scott case, said he would, of course, recognize the result between the parties, but it would not guide his administration in the policies they implemented and pursued. Is that possible, though? I mean, I guess it's also the case of, say, Cooper versus Aaron, where the court declares itself supreme, more or less, over the Constitution. So there's, I guess, your book makes very powerful arguments, one I'm inclined to agree with. I suppose, though, there's so much now that's happened in the 20th century, vindicating the court in many people's eyes. How does one even begin to unpack that? And we can talk about some of the problematic cases there, but I'd be interested to get your thoughts.
Yeah, I think, the most important thing to recognize about Marbury is that it does not assert judicial supremacy. It asserts judicial authority. So the court really deforms that in Cooper v. Aaron when they cite Marbury to say that they're the last word on constitutional meaning. I think without trying to weasel out of a question, that most constitutional questions ultimately come back to who we want to be as a people. So the court's power, as Hamilton noted, they didn't have the power of the sword or the power of the purse. All they had was the perception of legitimacy. And I think we as a people have surrendered our Republican responsibilities, not just our Republican authority, but our Republican responsibilities to the court. And unless we can reclaim a sense that two things. One is that the power of judges is important. It's one voice, but it's only one voice. And the second is that we've got to begin to see constitutional law as a people in terms of, in constitutional meaning, I should say, in terms of more than whose ox is being gored. Did I or did I not like the decision? So yesterday, for example, Elizabeth Warren had I think it was a tweet in which she said that her promise was to appoint judges who would vindicate workers.
Yep.
Right? No self-respecting judge would agree to an appointment under those circumstances. That's not to say all judges are self-respecting, of course, but that's as much as to say that she's deciding cases based on, she wants cases decided based on who wins and who loses and not what the law says.
Well, Barack Obama said he would appoint judges to the Supreme Court who are empathetic with the poor
Correct.
and the underprivileged.
Right. Right.
So in a way but that Warren statement, the Obama statement, is really a recognition of the political nature of the Supreme Court and of its immense power and of their desire for it to bring their progressive values to their decisions.
I think it's certainly a desire. It's certainly a statement of the latter, the desire to use the court as a hammer to impose one's will, which happens on both right and left now. I don't think it's a statement of the political nature of the court if we understand politics properly. If we understand politics properly to include constitutional politics, the court has its voice. It's just not the only voice, and that's the mistake that I think we tend to make.
Yeah. I'm gonna read. This is a good sentence you've got in the opening chapter, the Republican Constitution, and maybe I'll get your comment, more elaboration here. You say, quote, "The Federalist assumes both that the sole protection, the only effective protection for rights, comes from seasoned, deliberate majorities themselves, and crucially that there is no particular reason to believe judges would be any better at this protection than the people." But yet we do believe that, largely now.
We do, and we've come to see the Constitution as a abstruse, almost Talmudic text that requires the intervention of this, again, when I call this priesthood of judges to interpret it, when in fact its meaning is it's written in fairly simple language and is not much good as a governing document if us ordinary people can't figure out what it means. In the book, I refer to what I call the paradox of engagement, and the paradox of engagement is this: the argument is that we need judges to impose constitutional standards and decisions, because we can't trust anybody with power. Well, the question is then, why should we trust? If we can't trust anybody with power, why are we trusting judges with so much power? In fact, I would take it a step further and say the fact that judges are, in the way we've interpreted the system, unaccountable might make them particularly prone to abuse. As the anti-federalist Buddhist said that they're in criticizing the proposed Supreme Court that there was no, when he said there was no power to correct their decisions, he said that they're short of they're independent of the people, and every power under heaven, and men in placed in such a situation will soon consider themselves independent of heaven itself.
Yeah, no. Well, it seems as well, and you offer criticisms. I mean, judicial engagement is a kind of originalism. Typically, we'll also frame maybe a libertarian originalism, but you have just originalism itself, which has become dominant within center-right conservative circles. Even Jack Balkin, a progressive law professor at Yale, calls himself that.
Right.
You take on originalism as well, largely for the desire, this belief that the meaning of the Constitution can in fact be delivered through judicial decisions, but you're arguing each branch has the responsibility to do that, not just judges. So is your beef with, or maybe I'm projecting or imposing something onto you, Greg, you're not contesting originalism, you are contesting the responsibility and power originalism does seem to put in the judicial branch.
That's exactly right.
Yeah.
So I definitely am an originalist. The question is, who has the authority to decide what the original meaning is? And the answer is, again, the courts are a voice, but the elected branches are just as important. And the people acting through their deliberate will have the most important voice. And by the way, one of the things Lou Fisher has shown is that Congress has a much better track record over time protecting rights than the courts do. So that's why I say there's no particular reason we should just assume that judges will get these questions right, particularly if there's no one to correct them.
Talk about your chapter, because I think so much of this, Greg, and maybe I'm wrong, but this is really a deep discussion about politics and the meaning of politics and the insistence of dominant, say, movements in American politics to sort of degrade politics. We've been talking about the way libertarians view politics. There's also how progressives view politics, which isn't so noble either, because it's a deference to experts and science that can somehow be formulated into policy. But you have a different account, and I think you bring that out in that chapter. Talk more about that.
Yeah, I think judicial engagement is essentially a constitutional form or a legal form of the progressive aspiration to scientific legislation. It's a way of saying that we're not going to trust political processes. We're not going to trust the deliberate sense of the people. We're going to take this one activity and transfer it to experts. I think that in itself is a problem for if you believe that politics is a good life for human beings. But I also think it's a problem of originalism, because it's very hard to attribute that view to the founders or to the original public meaning of the Constitution. So these originalists who embrace judicial engagement on the right, or judicial, we would call judicial activism on the left, really have a problem, because they may seek originalist outcomes, but they're not trying to pursue them by originalist means.
So talk more about that, in particular, the founders and originalism, which I think is maybe also a discussion you have in the book in your James Madison chapter. But maybe get more into this, because I think what you argue in the book is, well, there's actually an assumption of the primacy of politics amongst the founders.
Right. Yes. I talk mainly through the lens of Madison, because I think he sort of bridges several camps in the founding. But there is nowhere in Madison or in Hamilton or or I think, by the way, even in John Marshall, where you can extract a theory of judicial supremacy or judicial finality from the founding. These again are men who are steeped in the classical political tradition, in the small R Republican tradition, and who believe very deeply in self-government.
So when we think about that, so there is momentous decisions, though, in the early Republic, judicial decisions that shape the direction and nature of the country that don't come through Congress or the president. When we can talk about those decisions, did we not, is it the court judicial review? It is going to declare the constitutional rule or rules, and we're going to be governed by those in a way as is part of just the regime itself working itself out.
Yeah, so you could make an argument that this is a case of Madisonian liquidation of the Constitution, as Federalist 37, and it's unclear who pronounces unconstitutional meaning. So we sort of work that out in practice over time. But I don't think that's what the Constitution itself says, and I don't think that's what any of the early exponents of the Constitution say. That there is a lot of path dependence behind an inertia behind the idea of judicial finality or judicial supremacy, but I think in the scheme of things, that's fairly recent. So the court, for example, decides almost no cases on the basis of the Bill of Rights until the late 19th, early 20th century. So the idea that the Bill of Rights is a cudgel for the courts to use to impose their view of natural rights is, as I've said before, if that was intended to be a weapon, it took them a long time to pick it up.
Think about Madison. Great chapter there. Authority versus how decisions are evaluated. And you've mentioned maybe part of that with the liquidation. We've discussed that a lot on Law and Liberty as well. But thinking about Madison here, also the man who introduces the Bill of Rights in the first Congress,
right,
attributed to be the father of the Constitution. Of course, that's heavily disputed. But how did he see constitutional interpretation working itself out?
Well, specifically with respect to the Bill of Rights, he does refer to the judiciary using the Bill of Rights to guard against encroachments by the executive and the legislative. But that seems to be more of a question of political, of tyranny, rather than what George Carey and others would call political oppression. In other words, there's no point at which Madison seems to see the Bill of Rights as a way for popular minorities to protect themselves from popular majorities. In fact, he says in the speech introducing the Bill of Rights that wouldn't work anyway. Right? That may be the great defect of the Bill of Rights is that it won't serve that purpose because the bills of rights are least useful when most necessary. So I don't think there's. Let me say one other thing, which is that late in life, when we have decisions like McCullough and so on and so forth, and he has some famous correspondence on that. It's very interesting that he says he wants judges to first of all limit themselves to the facts of the case. He's upset with Marshall for including abstract constitutional doctrine in his decisions. It's not so what we call dicta, I suppose. It's not necessary to decide the case. And second, he thinks that judges should pronounce their decisions seriatim, or one by one, rather than the court speaking with a unified voice. It seems to me that would have the effect of diluting the power of precedent.
Thinking here, Madison, on this idea of liquidation in particular is important. I think it stresses a way in which he thinks about constitutional interpretation happening amongst the three branches in a way you describe in the book, as opposed to a judicial finality course. And in particular, his example on the bank, maybe talk a little bit about that.
Yeah, so do you mean the correspondence on the bank?
Yeah, the correspondence and just sort of
his views on the bank generally.
Yeah.
Well, so there's a couple interesting things here. One is the correspondence that I just mentioned, but the second is that Madison leads the charge against the constitutionality of the national bank early in Congress, right, when he's a member of the House. That in itself is very striking because McCullough doesn't get to the courts until effectively a generation later. Everybody seemed to understand that the decisions about the constitutionality of the bank were to be worked out through political processes and through argument in Congress and so forth. The second interesting thing, and I think it's problematic in its way, or at least is pregnant with potential problems, is that when Madison is president, he having spent much of his career arguing against the constitutionality of the national bank, says in a veto message that he is waiving that concern on the grounds that the public has repeatedly, through all three branches of government, declared the bank to be constitutional. So who is he to impose one individual will on the constitutional judgment of the people? So there's an assumption latent there that it's the constitutional judgment of the people that ultimately matters.
Yeah. So in a way, that in of itself would sort of back up or reinforce this idea of a republic, of a political thing determining and shaping the Constitution itself.
That's right.
Yeah,
that's right. And I might add here that Adam White, who I mentioned earlier, had a fascinating thought experiment once, which is that would you want he asked this of Randy Barnett, would you want a Supreme Court of one if you got to pick the justice? Right? And because that again goes back to this issue of there being some sort of technical expertise that is necessary to interpret the Constitution. And it's exactly what Madison rejects here. He's not willing to say my view of the Constitution trumps that of the people, even if my view is right.
So let's think, though, also of, I mean, this is a question, too, I wanted to ask you, just listening to you talk. Think about the 14th Amendment itself incorporating the Bills of Right, the Bill of Rights against the states, largely all provisions of the Bill of Rights at this point. What does that mean for the judicial power? Because that's been a judicial move, assertion that happened decades after the 14th Amendment was ratified, but it invites constant opinions from the court, given the immense pluralism of our country and the ways in which laws can be challenged by people.
Right. So someone like Randy Barnett, who's I think among the most distinguished advocates of and smartest of judicial engagement, says that the 14th Amendment was intended to work a fundamental transformation in the system of federalism. I don't see much evidence for that in the ratification debates. I do think there's a pretty good case to be made that they incorporate the Privileges and Immunities Clause was intended to incorporate the first state amendments against the state.
That would be Kurt Lash. Kurt Lash has been.
That's Kurt Lash's thesis,
right.
And I think he's got pretty good historical evidence for it. I think that would have been a much better vehicle than the due process clause, where it really can't carry that, can't bear that burden. But the idea that it was intended to subject state laws to judicial review as a matter of routine, the federal judicial review, I think it would have been impossible to get it through the states at that point.
Yeah, it's. I mean, to my mind, there are. And I'm just thinking about your view, your book, your argument in this book, but the accretions of power, or not even accretions of power, just transformations of power, but also the administrative state as well.
Yeah.
And I can see your response there. But I guess one thing is it's not even majorities oppressing minorities. I mean, any interest now could find a way to get something in that allows them to make money or profit at the expense of the public at large because of these bodies that are constantly at work.
Yeah.
So I guess don't we, so maybe the initial engagement people have a point. Maybe we do want this judiciary active because the politics itself are just so out of control.
Well, if the purpose of judicial activity in that case is to transfer authority back to political branches through the non-delegation doctrine, that I think is a much more compelling case than saying since the administrative state is imposing its will, it would be better to have judges impose their will because they're equally anti-political. I have what I'm sure is a controversial discussion of the Lee Optical case in the last chapter, if I recall, in which I say that special interest legislation, which in action by special interest action by the administrative state, is a function not so much of institutional failure, although there is some of that, is it being the inevitable, simply inescapable consequence of saying we're going to have government micromanage the economy.
Yeah. No, and I mean, but the fundamental point too, I think, is the size and scope of the administrative state. Even if you were to say, reverse Chevron doctrine, which is the doctrine that allows administrative bodies to interpret statutes in the formulation of their regulations, as long as it's not arbitrary, their rules. And then you've got our deference, which is even when we interpret their own regulations, as long as it's reasonable, et cetera. What is reasonable? But even if you take away those, the judiciary takes away those, you're still left with this immense body that's still working all the time. I guess fundamentally, if you're concerned about the administrative state, it's going to have to be a congressional reorganization of it.
I think that's right. I do not think it is the job of the courts under the constitutional regime to be a referee between the executive branch and the legislative branch. I think the legislative branch has to be willing to assert itself, and behind that, by the way, the people have to be willing to pressure the Congress to do that. So I think by the way, in favor of judicial intervention that enhances the access to the political process or the vitality of the political process. So the case in the book is not by any means that the court should never act. It's that the court should not act in a way that undermines politics.
Yeah. So let's think about some of these hard cases that are frequently held up. You've mentioned, we'll come back to Lee Optical, but we can also talk about Dred Scott, but that's a very difficult case to discuss given everything that's going on. That's an activist case, though, undoubtedly an activist case that tilts us towards civil war. Roe versus Wade is an activist case that fundamentally poisons our politics, but there's also Brown versus Board of Education. How does your analysis deal with that situation?
Well, the way my analysis would deal with Brown is the way that Clarence Thomas would, which is to say the 14th Amendment prohibits racial classifications, period. That the problem with Brown, as many people have said before, is that you don't need all the importation of social science and the arguments about self-esteem and so on and so forth to simply say this amendment says you can't make legal classifications on the basis of race.
So, but that equality. I mean, the originalists themselves toiled over that until largely it's seen being settled by a law review article by Michael McConnell in terms of how originalists came up. But it was not at all clear, if you take that seriously, that you could get that from the 14th Amendment, because there was, in fact, segregation at the time it was being ratified, and no one thought, I could challenge that.
Right. I think that's a fair point, but I would make a distinction between what the original meaning of the Constitution actually is and the way that it was understood to apply to policy at the time. So it would not be unusual or unforgivable if people at the time they enacted a constitutional provision were not willing to go as far as in implementing the provision as the text actually dictates.
The provision actually allows.
Right.
Okay. Lee Optical, under discussion a lot. And I think here also we kind of come back to a decision of what does it mean for a judge to review a piece of legislation or to review a challenge law or rule.
Right.
So yeah, go ahead.
Well, I was just going to say with Lee Optical, I'm actually much more sympathetic to it than most originalists are, in the sense that there's a fair criticism of Lee Optical that it sets up a standard of rationality that would be hard not to meet. But I'm not sure the deference that is paid to the legislature there, I think, is appropriate. I think the real problem there is I've said before, is not the fact that there is rent seeking, but there's the provision of rent. So as soon as you have a legislature that's willing to micromanage economic outcomes, you have that rent seeking activity. I don't think it's eradicable from that point of view. And more to the point of your question, I don't think it's the job of judges to undo. I think it's the job of the deliberate public. I think, by the way, that it is also a function of the fact that not simply that government intervenes, but that it intervenes in so many small things.
Yeah.
So you could take an example like Social Security and say, well, it's either, setting aside the fiscal problems, you can say it's either a good program or a bad program, but everybody knows it's there and everybody can make a reasoned judgment on it. When a legislature is regulating everything from who can fit eyeglasses to your face to other microscopic problems, then it becomes much more difficult for the people to keep up with it.
Yeah, well, and I think that's and really that's a question of the scope of politics and the ways in which modern societies just present so many more problems to the government that they want to have solved for them. I guess the question too, though, is the way in which a judge reviews the law. And so you look at, I mean, this is sort of the argument made about Lochner. You know this is class-based legislation. There's significant evidence that one group is trying to hurt another group, just like with Lee Optical. You're trying to prevent commerce.
Right.
And so you don't think a judge, though, with that evidence on record, is now sort of given stature to undo that in the name of, this is just unfair. And I've got to watch the legislature. What does that mean? I don't know.
Well, I think the fact that legislation is class-based or that it inhibits commerce does not make it first of all, it doesn't necessarily make it a constitutional problem, right? But secondly, to the extent it is a constitutional problem, the legislature should be debating that, just like they did with the National Bank in the 1790s. So this again goes back to the point that the fact that an issue is constitutional doesn't necessarily make it judicial. And in fact, by the way, I think there's a real risk of moral hazard here, which is that if I'm a legislature and I know that no matter what ridiculous favor I pay off to a contributor or a friend or whatever, that the judges will in Arlen Specter's infamous phrase, will clean it up, then I'm much more likely to behave that way in the first place.
Yeah. No, I agree there. It's interesting. I mean, the moral hazard question is throughout our politics, particularly our federal, our senators and congressional representatives. You hear this a lot. The courts must decide. We'll have to let the courts decide. George W. Bush signed McCain-Feingold, and almost in the same act of signing it said, well, the court will tell us, what's constitutional or not.
That's right, after he had campaigned on the idea that it was unconstitutional.
Absolutely incredible. And when this just sort of goes on, and then, of course, the same deference is paid or desire for the administrative state to take political questions off their hands as well. So which could suggest, in a way, we have now become anti-political.
I think we definitely have. I mean, one piece of evidence for this, with which I opened the book, is that after Citizens United, when President Obama criticized the decision in the State of the Union address that immediately followed the decision, there was apoplexy. There was that anybody was criticizing the courts.
I know.
Now, I think it may have been impolite or unbecoming to criticize the justices to their face in a form in which they couldn't respond. But there's utterly nothing wrong with the president saying, "I think the court got it wrong." So I think we've come to see the court in this bizarre way as both enormously powerful and enormously fragile. So that they claim all this power for themselves, and if anybody so much as criticizes them or touches it or tries to skirt jurisdiction, the whole idea of judicial independence is somehow going to fall apart.
Do you attribute that? I mean, there's a lot of things we could attribute to that result. I tend to think they're the only people in our federal system of government who really make arguments for what they do.
Right.
And it's actually persuasive. And no one else tends to really do that anymore. I don't know.
I think that's right. I think part of that is because people are making statements to their bases and not the fragmentation of media and whatnot. There's not really even a forum for reaching across the aisle. I think another problem with that, by the way, is and I don't want to suggest I oppose this because I think on the whole it's a good thing, but it's C-SPAN. So when you start filming the debates of Congress, members of Congress don't have to be in the chamber in order to participate or in order to hear what's going on. So I don't know if it's fair to say the majority, but certainly a great number of the important speeches in the Senate or the House or places where people might disagree with each other, you're speaking to an empty chamber.
Yeah. Well, it's interesting. This might be an apples and oranges comparison to contrast. It is an apples and oranges comparison to contrast the House of Commons in the United Kingdom and those debates, which are supposed to largely happen without judicial review, versus the ones that happen in the United States Congress. I've always thought, is that why? Because everything is sort of final. Parliament is sovereign. And in our system, you never really see debates on the floor. Although the United States Senate at times in the 19th century was the source of grand constitutional debate and struggle.
Yeah, I think this is a symptom of a social ill, if that's not too strong of a word, which is that we generally demonize disagreement. Which is to say, not we demonize people we disagree with. We do some of that too, but we demonize the concept of disagreement itself. I think that partly stems from a sort of relativism where it's not just wrong to make truth claims, but it's somehow impolite because you might hurt somebody's feelings.
Yeah, well, that's definitely true with our millennials, as you know, in the classroom.
Yeah.
So I've been told. That's right. So I've been told.
No, that's absolutely right. There's a real discomfort with argumentation.
What do you? Something that is also brought up here is ignorance of the voter. Voter ignorance, thus implying consent of the governed, is itself an illegitimate concept. How do you respond to that?
Well, I respond to that by saying let's call the whole thing off. If we can't, if in fact it is inconceivable to have a thoughtful public, or at least a public engaged enough, as Madison said, we don't need we don't need voters to be virtuous. We just need to be able to identify men of virtue. If we can't do that, then let's stop trotting out the word Republican to describe what we're doing, what we're really describing as a judicial protectorate.
Yeah. Well, the consent of the governed, also, what does that mean in terms of what they're supposed to know about public deliberation? I mean, in the Federalist Papers, it means pick good representatives. That's what you can know. That's one thing you can know reasonably well. Right.
In terms of policy, you mean?
Yeah.
Yeah, I mean that again goes to the idea that as Madison says in Federalist 10, that the job of representatives is to refine and enlarge their public views. That's very different than Burke's view of representation. Burke's view of representation is I'm accountable to God for my own for the votes that I cast and the views that I espouse.
Yeah.
The Federalists, and Madison in particular, is really using public opinion as the raw material, but it's trying to season it along the way. And if that can't work, we've got much bigger problems than who's in charge of interpreting the Constitution.
Greg Wiener, thank you so much for joining us today. We've been discussing your new book, The Political Constitution, The Case Against Judicial Supremacy. Thank you so much.
It's been a pleasure.
This is Richard Reinsch. You've been listening to another episode of Liberty Law Talk, available at lawliberty.org.